Uh, with your kind permission, sir, can we start?
Oh, sure. If time is scheduled and if all participants are present.
Yes, sir. All the participants mostly are present, and others will join in the meantime.
Okay. Please go
Uh,
ahead.
Good evening to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Shri Tushar Vyas sir, and to all the participants in this second day of 15 days online national capacity building program on land, real estate, and property laws, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy. Organize this program under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar sir, former Judge of Supreme Court of India and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah sir, former Judge of Supreme Court of India, and Pro Bono India, which is working towards legal literacy and legal aid, where today's session is all about step by step guide to conduct due diligence before acquiring land or property. Before we start the session, please adhere to some webinar etiquette. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hand. Now, I would like to take honor to our esteemed keynote speaker, Tushar Vyas sir, Advocate, High Court of Gujarat. Sir is a practicing lawyer with over 43 years of experience. Sir also serves as a mediator and conducts training sessions and workshops in legal field. His remarkable contributions include authoring two unique legal publications considered first of their kind in our time. In addition to his legal expertise, Sir is a noted speaker on the Bhagavad Gita and ancient Indian culture, sharing deep insights drawn from tradition and philosophy. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you. Well, good evening to all. I'm really happy to share my views on the due diligence in respect to Transfer of Property Act and the laws, bylaws, and other regulations of Revenue Authority. Friends, first, the important thing is one of the canon of our law is buyer be aware. It is the buyer who has to be well sure he has to protect his own interests in case of anything, any risk, any issues arises later after the deal is over, then seller can escape from his responsibility, except in the case of a fraud. I think my voice is a little all right, or am I fully audible?
Yes, sir, you are audible.
Okay. Shall we go ahead?
Yes, sir.
So the first thing is about the buyer. The risk, the in entire this process of purchase of a property, and there is an immovable property. The entire risk mean more on buyer rather than a seller. Now, ideally speaking, seller has to disclose all the major as well as minor issues related to the property and its rights and the shareholder, the stake involved, and the interest of his or any his own his member of family, or is a if he is a company or a partnership firms, their respective stakeholders. But in case Suppose a seller is not making true disclosure. Ideally speaking, seller must disclose. But then nowadays, looking to the competitive field of this uh, corporate practice, as well as in a routine day-to-day life, people's greediness and selfishness are increasing, irrespective of the basic norms of ethical dealing. If a seller is governed by or is having a sound background of his ethical sense and belongings, then he may make it a true disclosure. Suppose he doesn't, and therefore the question arises of buyer's responsibility, that buyer has to take his own care at his own risk. Now, the first thing, how much, what span of the practice or what span of the search? The law says that at least by last 30 years, the buyer has to investigate the title and take care of all the preceding transactions carried out by seller and his member of family or whosoever is connected. Now, why is 30 years? Because that property interest, immovable property interest as such, till whosoever, suppose that there is a minor or their banquet, when there is certain conditions. So all these things are so coupled with or involved with transaction of sale. One of the party, because of, if a property is a big, huge property, there may be more than one stakeholders. There may more than one owners or co-owners, joint owners. Then everyone's interest is to be taken care, and therefore, all in as per law as well as recent judgment of Kima Rimani versus Collector Rajkot, it is said that a buyer has to take care, and in that circumstances, only you can't depend upon the revenue authorities, and revenue authority will not be able to decide the title. The rights or obligations or privileges or share must be finally decided or ruled by the civil code. Now, rest of the entire things, property related matters, revenue is the revenue office or revenue authority is only taking care, because in all land, which is land, maybe agricultural land or even non-agricultural land, their entries are recorded in village form number 7 of the 12, and rest of the abstract. That revenue authority is for the fiscal purpose. Revenue authority put down your name as a owner, or more, if there is more than one owner, then more there other names may be added. But simply having the name on the village form number 7 of 12 does not make you as a absolute owner of a title, because title can be decided in case of all controversies only by civil courts. Because why civil court? Because civil court will adjudicate. Suppose in revenue authorities there is a name of Mr. X is there, and Y is claiming that I am a legal heir. So I want that my name should be added, or my rights are not seen. then in case of such controversy, that the controversy, the authority, revenue authority is not supposed to decide, because he has no authority to adjudicate. The order of the revenue authority is not a judicial order, because it is not exercised by leading evidence, examining the witnesses, and according to law, the final verdict about the ownership. So all rights and privileges or interests can be only decided by civil courts. So there are canon of judgments, and even the law is the same. Now, suppose you are a buyer. What you will do now, step two, we will go one by one. First of all, you may ask the party, a seller, that friend, please furnish me all the relevant documents you have regarding the properties. In case if a genuine seller, he will supply all the papers. Number one, papers should be, all the documents should be original one. Why original one? Because if you ask the copy of the sale deed, seller may produce a Xerox copy of the sale deed or even true copy of the sale deed. When you ask him to produce the original sale certificate or the sale deed, in case party may not be able to produce it. When you repeatedly insist that no, in any circumstances I want the original one, then the fact may get disclosed that original sale deed is lying with the bank or any financial institution. So unless otherwise, the risk or any mortgage or any transactions or any pledge is made on the property, their original certificates or original sale deed might be having with that financial institution. So in case the party is not able to produce the original certificate sale deed, then the first objections or first question arises that why? And then it is you have to take care of procuring the original one, or then there is a substitute or other option. Now, second thing is that you have to ask the party. Then, my dear friend, you are ready to sell this property, but kindly tell me or kindly give me the exact detailed numbering area of a area involved. If it is a land, the square feet, not only square feet, length and width, and surrounding wall, having a right of exit and entry or passing road, all the smallest details pertaining to the land or a plot, you have to ask that kindly give me the details along with a map. Map, not only simply sketch done by his own handwriting or his own way, but the map which may be authorized by the city survey or the gram panchayat if it is a village, or if it is city, then urban development authority or even corporation where the plan is submitted. So that plan, and that plan consists of area, length and width and north and south and everything is there. So you have to match it. So first you get the papers. In paper, you kindly verify the numbers, subdivision number, survey number so and so, oblique so and so, part so and so, whether these numbers or these details tally from the document of which is submitted in front of you, a vis-a-vis that the figures or details with the sub-registrar office, city survey office, or a panchayat office. When you are able to match that everything is go through, then the next question arises about transfer of properties and section 56, 55, 56 by 6, that rights of a purchaser. See, seller has no risk. Seller is only concerned about the price. He may be interested in bargaining and earning maximum he can, but once the deal is finalized or the amount is finalized, the figure is finalized, then seller lose the interest. He is only think that as soon as the payment is received or not. The moment so far the payment is not received by the seller might be cooperating, but before that, it is the buyer who has to take care one by one all the requirements, that tomorrow, once the deal is over, then if the seller is not available, suppose he may leave the out of country, or he is, if is old age, he may not survive, then the question arises that any defect in title, any defect or any weaknesses in title is, who will recover? Who will compensate? And therefore, it is utmost importance and requirement of a buyer to be very, very cautious at the time of purchase or at the time of finalizing deal. Ideally speaking, buyer simply should not depend upon his own informations or data gathered. Ideally speaking, buyer has to leave the issue to some agent or a official person who is taking due diligence in respective offices, because his professor is doing the same thing for years together. So he is an excellent experience. He is a neutral mind. But once, because you say that in many cases we are people come across to us, sir, I have taken enough care. It was found okay because we were good friends. I believe it. I relied upon him. I trusted him, and then I made the deal. Sorry, this is here the question of trust or relationship or your past experience or your friendship should not come in the way. You should be simply neutral. You have to make it clear to your seller that, friend, I agree with the price which you have committed or which you have suggested, but please don't mind. I will have to take independent search, and that independent search, I don't doubt about your integrity. I don't doubt about what you say, but uh, law says that I had to take care. Now, how much care we have to take? There is list of offices, list of places, and list of stages where a buyer has to start from the due diligence. Because the word is a diligence. It's a due diligence. You can't simply like that. When I asked him, he submitted, and then I accepted it. I believe that it might be true. No, that is your assumptions, presumptions has no value in the eyes of law. Number one, the first is the sub-registrar's office, the entire troll. I think this search, if you have not visited the sub-registrar office, then it is difficult for to understand, but I can give you an example. Nowadays, we are receiving email. Now, email has a trawl of the mail that I asked you certain things, you reply, then I again call you and ask further detail, then you further reply. So, entire trawl is there. The sequence of our communications exists very much there in the email. Similarly, in sub-registrar office, or even in if it is a local one, then everyone in a panchayat office, talati office, find out the title, the deeds of the transactions, what last transactions, when it happened. So professional person like any junior clerk or an experienced revenue retired person, a mamlatdar person, offices, or even in some cases, even the lawyers are also exclusively working in this field of taking due diligence. So number one is sub-registrar's office. Number two is city survey office. Here also you need to get the last 30 years scroll that it passes from whom to whom to whom to whom to whom. And today, present owner enjoy this property. Then third thing is whether the property is purely owned by him, is a ownership, or is leasehold property. See, ownership, if it is owner self-owned property, then it is something different. If it is leasehold, then situations arise. Then, if you ask that, please furnish with a document of this property. Any documents are furnished to you, you need to examine. But friends, if a buyer is not fully aware about the legal terminology, ideally speaking, he should hand over the papers to his own lawyer. See, basically, this issue were nicely done or meticulously done by solicitors. Earlier, this was a system available in British time that solicitors were mainly taking care of this property dealings, and then they have the agencies or they have the set system. Then third thing is the district land records. You need to ask them to get it measurement. You might have heard, or in the document there might be showing that measurement x measurement is there, this much square meter or square feet, length and width is this much. Okay, fine, it may be there, it may be available, or it may be seen in the document, or even the map might have been attached to it. Whether this map or these boundaries matches physically with the actual measurement of the property, that we have to take care, and that is for that the city survey officer are authorized persons. They have the surveyor, and then they will certify it. Well, this property has this much area is as per map or as per record available to in the government authorities. Because in revenue authority, my plot might be having area of 1,200 square feet, but actually it might be 1,800 or 1,900 as per the government revenue record, city service record. So then the question arises of disputes, and this in such dispute, then salary is not available at that time. Therefore, before making a deal, please verify your map as per which is attached to you, which is furnished to you, along with the surveyor of land record, district land officers. Then the question arises: if it is a property which is a building or a house or a commercial property or any a tenement or even towers. First of all, the buyer has to ask about the permission to construct. Whether this building is constructed or built up duly as per the approved plan. Suppose a building might be looking a decent one, having a latest infrastructure and superb attractive ambience and everything. But if there is any flaws on bylaws and weaknesses of the development, building permissions and occupation certificates, all these formalities or covenants are not fulfilled, then tomorrow question arises that building which is standing maybe from years, but any time it is liable to be questioned, challenged, and we have seen now the action of even bulldozers, that bulldozers can come and demolish. Therefore, now any property which is constructed property, a buyer has to ask about the permission. Permission of the collector's first permission, which is from if it is revenue, I mean land agriculturist, then from agriculture to non-agriculture, then non-agriculture, then permission to build, that is Raja Chitti. Then as per Raja Chitti, if the building must fulfill the requirement of surrounding, if it is a plot, the surrounding area, surrounding land, entry, exit, and the FSI, that must be tally with the certified engineer of that corporation or that Mahanagar. Now, as per that building permission, then the question is around the occupation certificate. Building may be constructed well as per the plan or attractive plan to buy it, and there will be handsome advertisement, attractive discount, and offer are given. But whether have they occupied the occupation certificate? Because occupation certificate, the question of occupation certificate arises if the builder or a developer has not fulfilled the requirements or guidelines of the urban development authority regarding drainage, sewage, or any FSI, or parking, or even basement, or even other requirements, open land, then as well as even the height, and as well as certain material nowadays, even the even the rainwater harvesting, fire extinguishers, all these requirements are decided or suggested by the urban authorities. Whether if that is not fulfilled, that respective authority does not give you occupation. So that is BU. It is not good for use. So unless the occupation certificate is not given by the authority, then the question will be tomorrow. Anything can happen, and the buyer may be in trouble. Now, if it is a residential property, the first thing about the entry and exits road, then drinking water, drainage, light, telephone, all these facilities can be available. And what are the requirements, what are the arrangement the developer has made. Another thing is the FSI, flow space index. This is vary from city to city, but by and large there should be 1+1, 2+1, looking to the area, density of the population, etc., etc. But then, because if today I have purchased a tenement, but I do not have FSI, then I cannot go the further story or a multi-story or any other further constructions over that property. Then this residential property, usual thing is that whether nowadays in flood, whether this area is a catchment area where how the property is over flooded, or in case of heavy rain, what are the basic, I mean, or the main outlets of, because now in many cities now this drainage systems is highly under is every time it is under repair. There is not a single day, including city like Bombay, highly developed and advanced metro cities like Bombay. You see the every roads by and large, one or two roads are little bit open, and they have given the diversion. What for? That is the drainage. So drainage system must be taken care of. Your society or your tower drainage may be all okay, but what is that your drainage reaching to which chamber, which is the main well, where this is then is passing through, and is there any difficulty or any obstacles? Because if that drainage is not well, or even a chock up, or even that your area is not having such a level of the ground level or the slope level which is nearer to any river or even nala, then in case of a monsoon and heavy rain, your society or your tenement, your tower may be get over flooded, and then your property might get out of use for, and the entire hierarchy and the difficulties you have to face it. These are usual and normal issues of buyer has to take care, but that all thing is governed by the agents. Best thing is the agent first of all receive the papers and they appoint a lawyer or a solicitor. They give the public notice, and by public notice they are inviting, I mean they are disclosing their intention that whosoever is interested or whosoever is concerned may declare any of their rights, claim, objection, because tomorrow I am going to finalize this deal. So first a public notice, and public notice is the safest option, because in spite of 30 years search, because in many sub-registrar office, even the land records are not well maintained. Some of the years revenue records are even missing. So government will not be responsible. Therefore, when the seller will not may not accept the blame, therefore the best and the ideal option is to give public notice. Another best search is the search from the respective civil code. If it is a city, wherever the city is local jurisdiction, the local courts, you can find this. And now, fortunately, this online development and digitalizations, by and large, many revenue records in many cities and even small villages up to taluka level, documents are getting registered. E-Dara is having now everything recorded and digitalized. But friends, that online record is not 100% proof or 100% foolproof, because the online and data is available basis of the manual entry done by the respective officer or a clerk. In that circumstances, at the time of making a first entry, if there is error or if there is anything missing, that online record will exhibit the same thing, and therefore this you can't simply rely upon the online. But this e-record or e-dhara cannot be simply ignored. We have to nowadays we have to take care of that facilities. Please collect the data available which is online and then match with get it physically matched with the local area, local person of an agent or a lawyer or a clerk from that offices. If both the things are easily available and it is compared, then I think you get a little bit satisfactory result. Everything is you made a due diligence. See, there is endless job. Of course, it is in nutshell. It is difficult for me to explain the length and width of importance of due diligence. But the last thing which is there, you can a buyer can make that in case of seller, if he has committed or if he has left or something, sometimes it through his oversight, some issues may not be brought to his notice. So in that circumstances, that drafting of the sell deed makes if there is a brilliant drafting, then buyer can put that clause that in spite of this due diligence and in spite of the information received, we believe it and this is true and correct. But in case anything arises, any issues or any challenges regarding title or rights, then the seller will compensate. And it is the duty of the seller to compensate. Secondly, it's not that simply buyer is all the time will be loser if there is defective title. Only thing is that buyer will have to do the exercise and to explain the authority that he has taken the due diligence, but the seller has committed fraud. The seller has suppressed. The seller has not disclosed this thing in spite of my sincere and genuine efforts. Now, in with this much exercise, if you have made, and in spite of that, if the seller has purposefully, willingly suppressed certain things or made any mischief in transactions, then rights and interests of the buyer can be protected. But that all depend upon how you rely upon the lawyers. Another thing which I have found that this transactions of purchasing a property. If I can give you a very raw example, an example of a boy selecting a girl. See, both when they come in contact, both are impressed, both are influenced, and both are praising each other, and they are so eager, they are in so hurry that they want to marry, they want to come into relations, but by staying together, certain issues arises later on, and then it is too late. So here in this case, I was impressed by this property. I like this and I want to buy it. So here my impatience or my little hurry or my ignoring the advice, expert advice of a professional may cost me. And therefore, this is a little delicate stage. The first stage, this is the first stage. In case in first transactions, first stage, you left any stone untouched, that cost you heavily. And therefore, it's my humble advice that everyone at the time of purchasing, having little patience, be cool, should be matured and rely upon the rational advice of a professional, examining of documents, and then taking care of their transactions. I think this is if this was taken, then ultimately we don't know what is the fate, but it is said that property always pays you, and every time price is increasing, so buyer is always today whatever the amount, whatever the price they have paid, or I mean cost they have made, tomorrow it is going to having inflation and getting better price. So but at this point of time, any time or any expenses made in due diligence, this is an investment. It is not an expenses, but it is an investment, and then investment will certainly pay you. I think, according to me, right now, for this purpose, this due diligence covers by and large the entire gist of this exercise. But this exercise is mainly concerned with semi-legal person who are partly legal and partly revenue. Those who are well versed with revenue offices and revenue dealing, I think they are little very easy and smart enough to advise you. And therefore, besides lawyer, if you can engage, or if you can advise, or if you can learn the tips from the officers who are, or the person who are mainly working or taking care in revenue offices, I think they can give you the correct advice. This is all what I can say. Ultimately, in spite of everything, whatever is done, in case the buyer is a sufferer, or even a suffering loss, then there are courts, and courts are there to take care that what mistakes or suppressions or what blunders have been committed by a seller. And if it is proved, then buyer can be compensated. But friends, it's a long way to go. Therefore, why to wait and waste your time and energy? Instead, be patient, be cool. Let us wait for some time. Give the enough time and patience to the what urgent tips which you are receiving from the sellers or their your agents who are examining the title, and then only you can make the deal. I am sure is with this much due diligence, if a person is making any transactions, I think there is nothing much to worry, and then whatever the risk it may come, they have to face it. Thank you.
Thank you so much, sir. Now we open the floor for question and answer. Sir, there is an also some participants are from the Hyderabad and Maharashtra. So it
Hmm.
would be great if you can give the overview of the due diligence from that state, if that isn't different from the state of Gujarat.
No, nothing. By and large, the entire law, this law is a transfer, this mainly revenue laws are based on the transfer of property. So transfer of property is a central act, is governed everywhere across in pan India. So there is nothing, anything very main variation. Only few notifications or few restrictions or conditions may be made in certain states. But honestly speaking, I have no idea about even Hyderabad or Maharashtra. Therefore, you have to call somebody from Hyderabad, because whatever my advice may not be perfect one.
Participant, please raise your hand if any question query from your side. Sir, if you want to check my house documents, can I visit city survey and request?
Sure, you can. Only thing is that today, last 20, 30 years, it is okay. The question is arising after many old properties where your father and grandfather or even their third generations or fourth generations, they inherited the property by will, or they inherited property in certain cases, like they got it from the Inam, like Baroda is a state, and government, from state authority, their property is given to them. So how that passes to you? Even the property you should be well enough and wise enough. The property should not be having a trust or a charitable trust or a religious trust, and therefore this trail. Today the entire basic issue is what the burning issue of a nation, and even before the Supreme Court, is about the Waqf. Now, Waqf property, people are asking that why and how this property you have bequeathed. Show me the rights, show me the role, that how, when did you own it, or your father or your grandfather. So that is the issue, is that property, if it is too old, then certainly we have to be more cautious.
Another question, how does one confirm authenticity of original paper since there have been cases of original being forged? I will
I'm
come
sorry.
to Sir, how we can confirm authenticity of original paper? Because many cases are there, forgery of documents.
Hmm.
So how we can confirm documents are original or not?
Okay, friends. Now the first thing is about the forensic, whether the signatures may tell you or not. Then, if you produce me the cell deed, and I asked, when I made my public notice, then I can found that some revenue or banking or finance institution might be there, and that original any which is lying with the bank or institutions, we have to compare it. Or the thing is that we have to make an expert, because lawyer, vigilant lawyer can find it that this is an original one and this is a duplicate one, or some forged one.
Sir, if the seller
Here is
made
that Nataraj is asking that, or can we get a certified copy? Yes, we get a certified copy from the, if it is submitted before the court or it is submitted before the sub-registrar, you get the certified copy of the sub-registrar and then tally with the original one.
So there is one question that if property come from direct khatoni and current deed is executed in a residential purpose, then we need a CLU letter from the concerned authority.
Well, I have never come again. What is Katauni?
Uh, uh, Arjun, can you unmute yourself and ask your question directly to the sir? Sir, also one question that
Question is here from Pranav Thakkar, that what documents necessary to due diligence. So I have stated that first is a cell deed, copy of the cell deed, then the city service record, then the sanad of that property, sanad having a map. Then if it is from urban the city, then the municipal tax bill, electricity bills, every these bills are semi-government authorities are also are coupled with the main document, and then comparing everything, you can find that this is there is a list is complete one. But this is, we are not our own subject. We need to hire an agency, and then agency is the right source how to get it done.
Sir, there is one question that if seller made multiple agreement with multiple people on same land, how to identify?
See, it's a crime. Selling, if I have sold one property to more than one person, it's a offense punishable under Indian Penal Code. It's a criminal offense. But that can be the best thing which I suggested. That the best thing is that the public notice. Otherwise, without public notice, it is difficult for find out that whether the property which is offered to me is earlier sold or not. The one is the public notice, another one ask the original one. Ask the original certificate, sale certificate. Sale deed. Original sale deed might be if the person is possessing, then you can say that it is having with you own. But multiple, then it is a question of offense only and criminal offense. I have Gayakwadi Dastavej with handwritten. Yes, kindly, this is now already over. The screen is missing. The fellow was asking something about Gayakwadi old Dastavej and then is now missing.
Yes, sir. How can request city survey to show as a document, sir? That is a question from Sagar.
This is valid. If you have any document, of course, Gayakwadi in that time it was in a vernacular language or a Devanagari lipi. That dastavej or that copy of that deed, you can show it to the city survey. City survey might have been recorded. If not recorded, get it recorded as on date. Only thing is sometimes in many cases, city survey does not disclose the name of my property because my father might not have got it registered or grandfather, because at time of registering before the sub-registrar office, we have to pay certain things, certain amount or cess, and that fees, whatever the levy or the charges required to make an entry, that is not paid, then though you are owning the property, but in the revenue records, your main name may not exist. Therefore, this is the defect of a title. So you need to clarify or clear all your earlier role or earlier succession, make the official documents and declarations, submit the authority or affidavits or whatever the undertaking, pay the required fees, then your name will certainly appear on even the city survey office now from today onwards. There is a right course of action to get the register in your name.
Another question, through RTI, is it possible to apply for duplicate papers of any property?
I
Government.
agree, gentlemen, I agree, RTI. But how can we simply rely upon the RTI? Even RTI, the offices are only available whatever they have. It is we are supposed to take care. Let us furnish, at our own, we furnish the document and get the entries recorded. Because RTI's reply is not solely proof or will not absolve you that you have taken care. Is a only supportive answer. RTI's answers will be only supportive answer that is required to be corroborated with the existing the documents. Acha, what here is a question from Pranav Thakkar that what steps we have to take if the sale deed is lost. Forget it, no problem. If your sale deed is lost, it is lying with the sub-registrar, you can get the certified copy and then you submit it that in my absence, this sale deed is lost. I make it declare, and then therefore any true copy or certified copy available from the sub-registrar's office, registrar's office, that is as good as the original one. Only thing is you have to give an undertaking that this is the duplicate or this is a certified copy. In case of any time, original certificate or original sale deed is trace out or available to me, I will furnish it and I will not misuse it. I will not use it for any other purpose. I will have to surrender this one. Is okay.
So there
The
is a
title search report. There is nothing to draft the report. If the clerk is required to give in a standard format, that survey number, city survey number, then the area, then in the which year the first entry, when it was lying home, with when any mortgage, then it is mortgage is released or not. Everything is simply recording. There is no very difficult or any technical draft. It's a simple draft. A clerk is making, he is able to make it. How many of you have visited the revenue office?
Yes, participant, you can unmute yourself.
How many of you have, that is the point. Unless you don't visit the revenue offices, unless you do not visit the panchayat office or a talati's chora, friends, let me tell you, it is difficult. How many of you are able to read this village form number 7/12? That 7/12, the abstract, or form number 6. Of course, I don't know whether it has come in your syllabus or not. But ideally speaking, a good property consultant must understand the smallest point which is shown in the 7/12. You know, in 7/12, there are circles. If you find that 7/12, there are circles. That circles are very, very important. That circle itself suggests the entries. That this one entry was there, then another entry was this and that. Then the 7/12 there are brackets. So bracket is also have interpretations. So friends, simply having a law degree, of course, I do not know whether our law faculties are explaining us and making given training, practical training of this. But first and foremost, all these revenue records are required to be examined and understood very, very carefully. And then only you are able to make you the proper decision whether this property is a valid title or not.
Yes, sir. Another question, sir. What are the evidentiary value of records of rights? The evidence.
Evidence. These are the evidences. All village form and abstracts. Then your mesul which you are paying, or if it is a corporation, then the tax which I am paying. These are all records because I am paying my tax of my this tenement. There is one kind of document.
In title search report, how many documents we should analyze? Like, because we see so many titles, they keep putting all documents, these documents. How many are sufficient?
Number one, would you like to note down?
Yes, sir.
Yes.
Number one, the original sale deed. Number two, the city survey's record or abstract from city survey. Then the map, or which is the sanad. Then the corporation's tax receipt, or if it is panchayat, then it is a Mehsul Pauti. Then if it is a building one, then the building permission, building map. So there are number of requirements which bunch of this entire papers make a title. Simply one deed or one paper or one agreement does not is enough. There is enough all other documents which are supposed to be tally with the owner or the occupier or the shareholder which are having the stake involved. But that come across only when you exactly and physically deal with the transactions. If the buyer had taken loan on the property and the legal had been done by the bank lawyer, I think this question is incomplete. Is there any statutory duty of the talati to ensure the mutation intimated by the parties are correct? Yes. If a buyer has taken a loan from the bank, that loans or the pledge that must be disclosed to the talati, and then talati is required to put it on record. Otherwise, it is difficult because tomorrow one may not know that whether this property is free from encumbrances or not.
Then criminals or consequences in related to revenue matter. Criminal, like as you told, forgery in documents, which are others. Criminal,
Sorry.
so which are the criminal consequences related to revenue matters, like you told, forgery in documents, and which are others, like it can land up in criminal matters.
I know.
Yes, sir. So, sir, which are others that I have? That is a question. Criminal
What are the
matters.
responsibility? The question is disappeared. Registration office does not check the title holder while registering a will deed. Means anyone. What are the responsibilities of the society's secretary in case of a loan from another? It is a society. See, if it is a cooperative society has to keep a record and make an entry. But by and large, it is the duty of the financial authority to declare it. It is paid, and then every time, or by and large, they put the notices that this property is under pledge, or this property is under hypothecation, or this property is mortgage with so and so authority. And therefore, that is the first thing. Second, in support all that society, the secretary is also disclosed it. But unfortunately, cooperative society secretary does not have any authority, any legal status, legal authority. So they cannot are not able to take actions. And you know, in our country like India, if an authority doesn't have any powers to stop certain things, people don't obey that orders. And therefore, the only thing is that one has to rely upon the government authority or civil courts.
Srinivas IP, Srinivas.
Namaskar, sir.
D.
Sir,
Yes,
I am
please
not,
carry on.
sir, I am not asking any questions, sir. I am giving a little bit information that I know.
D.
Some participants are asking how to know on the same land, two or more registration have been done. How we can know? Like that they are asking.
So I see.
They have to go to they have to go to SRO for such report, and they have to inspect the books. In whatever documents are there, they will be recorded in the books of records in the sub-registry office. Book number 2, book number 1. It is written on the back side of our agreement, sale deed. So with that, we have to go and search in the book of records. Any duplicate by 1, by A or by B, 2 like that, they will add and they will register in the that book, sir. So we have to take the details of that thing, and we have to see the who is having physical possession are there. Like that, we have to go and we have to do our due diligence, and then if nobody is there means then only we will dare to take that property. Else we should leave where it is like that, sir. One more thing, one person has asked, suppose they have lost documents while it is kept in the bank, sir. If it amounts to breach of trust. We can banker has failed carrying his duties. Whenever we are placing documents with bankers, deposit of title deeds bill or one agreement will be there, sir. In that we will sign. It is 99% documents won't go, sir. But unfortunately, within 1%, anything can happen. They have to, bankers themselves have to give a police report, and they have to take all other precautions to bring back that property, papers back to us. Hmm. Thank you, sir. Thank you for giving
Right,
opportunity.
you are right. You are right. Now here I found one
That is
question
it.
that if a person is making a wrong or false information before the registers and it is been already registered, then what? Whether is there any check of the register? Well, ideally speaking or truly speaking, register has no check as such. Register is relying upon the statement made and the document furnished. But in case if a person has made a false entry or any defective covenant or defective entries are or details are made, then the only question is you can't simply cast entire responsibility on the register. You have to challenge it before the civil court. And in civil court, you have to prove it that this gentleman, the seller, made fraud or he paid mischief with the revenue or register authority, and therefore this name is shown. But that all entries, all false entries are can be simply rejected and cancelled. And that is a duty of the court, and that is why we lawyers are busy all the time. Because nowadays, in as such, by and large, almost 30-40% of the cases are related to properties cases and property related issues.
Sir, can I ask one question, sir?
Please, please.
Sir, you said that the search report should be of 30 years, sir. So, as per the doctrine of adverse possession, isn't it applicable that 30 years is for government properties and for 12 years it is for the private ones?
Well, for private, it is required, but government property, there is only thing is that you should go to the particular covenants which is there. But to be on safer side, it is advisable that you go for 30 years. Otherwise, as per transfer of property, 12 years is the adverse possession. So by and large, after 12 years, nobody's claim exists on private land. But since this tradition or this practice is coming from 30 years, it is advisable that we should go for 30 years.
Right. Thank you.
Okay, any other last question participant?
Yes, Mr. Srinivasan says it is 30 years. It is in our interest because the question does not arise for 12 years. The time and exercise which is done by your agent will the same hardly half an hour or 1 hour may be there, and few amount of charges will be there for more than 20 years or 30 years. So there is no sense in simply saving few government or registration fees for title search more than 12 years. In case you have taken 30 years search, you remain rest assured that there is nothing will happen. And whatever in case anything happen, then your rights will be protected. This is the best thing to be on safer side. It is for 30 years.
Can I
Yes,
ask a
Mahendra
question,
Lawan
please?
has raised his hand.
Yes,
Yeah,
sir.
can I ask a
Mahendra.
question, please?
Yes, yes, yes.
Yeah, sir, there's a question on that. There's a land which we have been in our possession, and it belongs to a ancestral property. There are 5, 6 brothers and all all of these expired. Then I think the offspring, they are not much bothered on that. They don't even care for that. But this property is being enjoyed by us, I mean by my father, and subsequently by me over the last 30 to 40 years. If I have to sell it, how should I do it? Because nobody is coming forward for such kind of a resolution and all the things. If I abandon this property, somebody will get possession and then he will not vacate also. What is the solution? If you can think it off and let me know something, either on mail or either through.
Yes. Did you completed your?
Hello.
Did you completed your question, Mahendra?
Sorry, sir.
Did you completed your question?
Yes, I completed it.
So, Mr. Mahendra, the best thing is that if the property is an old one, having more than one legal heirs, and if they are not available, they are expired, we need to get it their names be erected from the records, and that too there is a long process of submitting their death certificates, their legal heirs, then their pedigree. This is enough long exercise, and then one by one, everyone's name should be discharged, and then only your name, if you are alone, the legal heir, then it will stand on your name. But you need to obtain either that if the person is dead, then death certificate. If there are persons who are, say for example, ladies or sisters or some others, they have to relinquish their rights. That I have withdrawn my rights, and please delete my name as a owner of this property or co-owner of this property. It's a long exercise.
This process, no one is interested. People who left and their offspring, they are so rich, they don't even bother for this. And this has come to such a position that this property will get damaged and we have to go out for this. So no shortcut solution. So what is the way out? Litigation and all.
That's what I said, that you need
Yeah.
consult a good property lawyer. He knows
Okay.
the all ways out there. It's not that it is not so difficult for you, but the process is required to be fulfilled.
What I mean to say, someone told about 30 years possession or 12 years possession. He, as an occupant, has been enjoying this property for years, paying everything on electricity and water and all the things. Can basis on that, I can't go and pay the court, okay, I'm enjoying this property for years now. If someone has interest, let them come forward for this. How to invoke and invite their interest on it. If that solution, can we work out on this?
That's what I say, that you might be enjoying the possession physical possession,
Right.
or you might be getting your benefits or interest and from the property, but that simply possessions does not give you the title. You need to follow the due process, and that process is a long process. There is no option, there is no shortcuts, and my humble advice is, please don't go for shortcuts. Today it might be you find easy, tomorrow you or your even your in your family, your generation will suffer the great setback. Therefore,
Okay.
follow the
Nice.
due process.
But in case of advanced possession, how people do it? They don't go by this method. They also they also doing same thing on. I am enjoying this property for years, and this is advanced possession. That process is different from something.
I think, sir, we should take
Okay.
up
Thanks so much.
offline maybe, sir. Okay, sir, I think we should, sir, we are running short of time. So thank you very much, Tushar, sir, for your valuable time and then, practical aspects. Again, sir, you rightly stated we have to visit our office, how things works, right? So again, this is the basic understanding. And then especially say in law colleges, landlords not, unfortunately, very theoretical part. But again, they should try to have visit. I have not seen faculty, they took the student on visit to sub-register office, panchayat office. It should be the practice. While teaching any law, we are taking them to jail, court. But again, land and property related matter, I think 3, 4 subjects are there related to land, property. So we should plan this way so we'll get to know. At least one visit will suffice, maybe, sir. So thank you very
Intensive, the intensive period is meant for this only. The all law intern is supposed to visit all these agencies and office, physically, practical, having the experience, one-to-one live experience, and that can build up their understanding about the title.
true, sir. And it's just student also, they try to go in, just district court, especially high court, they are not starting for this is very basic thing. They start earning money from this revenue practices. So
Srinivas, the point is having internship in Supreme Court or High Court or even district court is little fancy.
yes, sir.
It is a glamorous. But visiting revenue offices or panchayat office, talati chora is little below dignity to a lawyer who is having
Thank you,
a
sir.
5 years law college in hi-fi expert environment. So basic, but the root, this revenue office is the root of the entire property transactions, and therefore forget about glamour, forget about the decency. You need to go to an approach and sit before the revenue office or talati. Then only you will be able to understand the smallest ins and outs of these documents and reading or interpreting the documents.
Thank you. Thank you very much, sir. Tushar sir, for valuable time, and then, sir, look forward to see you,
Fine.
sir.
Fine.
Thank you so much, sir, for this wonderful session.
Okay, fine.
Thank you everyone to join.